The certified letter arrived on a Tuesday morning, and Marcus Webb, a 42-year-old civil engineer, read it 3 times before the rage set in. HOA President Linda Hartwell was demanding immediate access to community water infrastructure on his property, the stone spillway his grandfather had built in 1962, decades before this neighborhood even existed. She'd already hired contractors. They'd be arriving Friday to assess modifications. Marcus set down his coffee and pulled out the original property survey from 1958. Linda Hartwell had no idea what she'd just started, but she was about to learn that some battles are lost before they even begin. Where are you from? Tell us in the comments below. And if you're loving this story, hit that like button and subscribe for more. Now, let's see exactly how this unfolded. This is a story in 3 parts. The violation that pushed a good person too far, the confrontation where power shifted completely, and the resolution where justice was finally served out in the first part. We'll walk through the months of escalating harassment that transformed Marcus from a quiet homeowner into someone willing to wage legal war. The certified letters that arrived with increasing frequency, each more threatening than the last. The contractors who showed up unannounced, tools in hand, ready to tear into property that wasn't theirs. The HOA meetings where Linda held court like a tyrant, convinced that her position gave her dominion over land she'd never owned. And the breaking point, the moment when Marcus realized that reason and documentation wouldn't be enough, that he'd need to drag this woman into court and dismantle her delusions. Piece by piece, the second part reveals the confrontation that changed everything. The emergency injunction hearing where Marcus arrived with 70 years of documentation. The moment Linda's smug confidence cracked as property boundaries were displayed on the courtroom screen. The judge's questions that grew sharper with each evasive answer Linda provided. And in the final part, we'll witness the resolution that reverberated through the entire community. Here's exactly how it happened. Marcus Webb had purchased a 2-acre property on Hollow Creek Lane in 2019, drawn by the same feature that had made his grandfather buy it in 1958. The natural stone spillway that channeled overflow from the seasonal creek through the eastern boundary. Marcus had spent his career designing water management systems for municipal projects across 3 states, and he recognized immediately what his grandfather had understood. This wasn't decorative landscaping. It was functional hydrology, preventing erosion and managing stormwater for the entire slope below. The property deed explicitly included the spillway and all water management features within the surveyed boundaries. Marcus kept those documents in a fireproof safe, along with photographs dating back decades. The trouble began in March 2024, 3 months after Linda Hartwell became HOA president. She was 51, a former real estate agent who'd never quite recovered from losing her license over undisclosed property defects. And she ran the Hollow Creek Homeowners Association like a personal fiefdom. Her first letter arrived on March 12th, addressed to property owner at 847 Hollow Creek Lane, informing Marcus that the HOA would be conducting a community water infrastructure assessment and required access to shared drainage features. Marcus called immediately, politely explaining that his property contained no shared features and that the spillway predated the HOA by 4 decades. Linda's response was clipped. "We'll be in touch." The second letter came April 3rd, more aggressive. Linda claimed the spillway affected community drainage and cited invented code violations. She demanded Marcus grant easement access within 15 days or face fines of $500 per day. Marcus responded with copies of his survey, his deed, and historical photographs showing the spillway's existence since 1962, when this entire development was still cornfields. He explained, in the patient tone he used with difficult clients, that she had no legal standing. Linda's response arrived via her lawyer, a fresh law school graduate named Todd who specialized in HOA disputes and clearly hadn't researched the case. The letter threatened immediate legal action unless Marcus complied. By May, Linda had escalated from threats to action. On May 14th, at 9:47 a.m., Marcus was working from his home office when he heard diesel engines in his driveway. Three men in hard hats were unloading equipment from a contractor's truck. Marcus stepped outside to find Linda Hartwell standing on his lawn, clipboard in hand, directing them toward the spillway. When Marcus approached, she smiled with the confidence of someone who'd never been told no. "We're here to modify the drainage system. The HOA has determined it's a community asset." Marcus kept his voice level. "You're on private property. Leave now, or I'm calling the sheriff." Linda actually laughed. "The HOA has jurisdiction over all community water features. Read your covenants." She hadn't read his deed. Marcus did call the sheriff. Deputy Martinez arrived, reviewed Marcus's property documents, and politely but firmly asked the contractors to leave. Linda stood beside her Mercedes, face red, finger jabbing toward Marcus. "This isn't over. We'll see what the courts say." Marcus met her eyes. "Yes, we will." The final straw came 3 weeks later. Marcus returned from a site inspection in Columbus to find survey stakes driven into his lawn, forming a perimeter around the spillway. Pink flags marked where Linda's hired surveyor had redefined the boundaries, claiming the water feature extended into community easement. The stakes were 10 feet inside Marcus's property line. That night, Marcus didn't sleep. Instead, he sat at his kitchen table, surrounded by decades of documentation, and drafted the most thorough legal filing of his career. If Linda wanted a war over property rights, he'd give her one she'd never forget. Marcus pulled up the contact information for Catherine Voss, the best property litigation attorney in the county, and typed an email that began, "I need to file an emergency injunction." The emergency hearing was set for June 18th at 2 p.m. in Courtroom 3B before Judge Raymond Foster, a 30-year veteran known for his impatience with frivolous property disputes. Marcus arrived at 1:30 p.m. with Catherine Voss, a 49-year-old attorney who built her reputation dismantling exactly the kind of overreach Linda represented. They carried 3 accordion files containing surveys dating to 1958. The original property transfer documents, historical photographs, and expert hydrological reports Marcus had commissioned. Linda arrived 15 minutes late with her attorney Todd, wearing a cream pantsuit and the expression of someone attending a formality before inevitable. Victory. Judge Foster wasted no time. "Ms. Hartwell, you're claiming the HOA has authority over a spillway structure on Mr. Webb's property. What's your legal basis?" Todd stood, shuffling papers. "Your Honor, the spillway affects community drainage patterns. The HOA covenants grant jurisdiction over shared water management infrastructure." Catherine was on her feet before Todd finished. "Your Honor, may I present the property survey from September 1958? She projected it onto the courtroom screen, a detailed map showing the spillway, entirely within the original property boundaries, stamped by a licensed surveyor and recorded with the county. This property and its water features existed 43 years before Hollow Creek Estates was developed. No HOA covenant can retroactively claim jurisdiction over pre-existing private infrastructure." Linda shifted in her seat. Judge Foster studied the projection. "Ms. Hartwell, when was your HOA established?" Linda cleared her throat. 2001, Your Honor. "And you're claiming authority over a structure built in 1962? Linda's face flushed. "The structure affects our community." Judge Foster's expression hardened. "That's not what I asked. Do you have any documentation showing the spillway was ever designated as community property?" Silence. Todd fumbled through his files. "We're still researching the historical records, Your Honor." Catherine placed another document on the projector Marcus's property deed with the legal description highlighted. "Your Honor, the deed explicitly includes all water management structures, including but not limited to the stone spillway located on the eastern boundary. This language has appeared in every title transfer since 1958. Mr. Webb's ownership is unambiguous." She advanced to the next image, photographs of the spillway from 1965, 1978, 1995, and 2020. Showing consistent maintenance by the property's owners. Furthermore, Mr. Webb has engaged in continuous exclusive control of this feature for 5 years. The HOA has never maintained it, never contributed to its upkeep, and until March of this year, never claimed any interest in it. Judge Foster turned to Linda. Ms. Hartwell, did you review the property deed before sending these demands? Linda's voice wavered. Our attorney advised us we had standing. Todd interjected. Your Honor, we believed. Judge Foster cut him off. I'm asking Ms. Hartwell, did you personally review the deed? Linda's shoulders sagged. No, Your Honor. Did you review any historical property records? No. Did you consult with a surveyor before placing stakes on Mr. Webb's property? The courtroom went silent. Linda's voice dropped to barely a whisper. No. Catherine delivered the final blow. Your Honor, Mr. Webb is a licensed civil engineer with 20 years of experience in water management systems. He's included an expert analysis of the spillway's function. She handed the judge a bound report. This structure prevents erosion that would damage multiple properties, including some outside HOA jurisdiction. Ms. Hartwell's proposed modifications would have destabilized the entire slope, potentially causing tens of thousands in damage. This wasn't an administrative overreach, it was reckless. Judge Foster set down the report and looked directly at Linda. I'm granting the injunction. The HOA is permanently barred from any interference with Mr. Webb's spillway or any other water feature on his property. You will remove all stakes and markers within 48 hours. Additionally, I'm ordering your HOA to pay Mr. Webb's legal fees and all costs associated with this action. Do you understand? Linda's voice cracked. Yes, Your Honor. As they left the courtroom, Marcus watched Linda hurry toward the parking garage, Todd trailing behind. She didn't look back. Marcus turned to Catherine. What happens now? Catherine smiled. Now we make sure this ruling gets entered into the HOA's permanent records. She won't forget this. The stakes and flags were gone by Friday evening. Marcus stood at his kitchen window, watching the contractor Linda had hired remove them one by one, loading them into his truck with the careful movements of someone who wanted no part of whatever dispute had led to this. The contractor caught Marcus's eye and gave an apologetic shrug before driving away. Marcus allowed himself a small smile. The first battle was won. The real fallout came at the next HOA meeting on June 27th. Marcus attended for the first time in 3 years. Sitting in the back row of the community center, while 47 homeowners filled the chairs around him. Linda stood at the podium, her usual confidence visibly diminished, and delivered the news that the HOA owed Marcus Webb $14,750 in legal fees and court costs. The room erupted. Questions flew from every direction. Why had she pursued a case without researching the property history? Who authorized spending HOA funds on a lawyer? What other properties was she planning to claim jurisdiction over? Marcus watched as neighbor after neighbor stood to voice concerns about Linda's leadership. Several had received similar threatening letters about community property that turned out to be entirely within their own boundaries, mailbox placements, fence lines, even a decorative fountain. Linda had been systematically trying to expand HOA authority beyond its legal limits, and the court ruling had finally exposed the pattern. By the meeting's end, a motion had been introduced to remove Linda from her position as president. The vote would occur at the next session. Linda left quickly, avoiding eye contact with everyone. Marcus stayed to speak with several neighbors who thanked him for standing his ground. One of them, Patricia Chun, a 58-year-old retired teacher, shook his hand warmly. She tried to tell me my rose garden needed HOA approval because it was visible from common areas. I almost tore it out. Thank you for fighting back. The formal vote came on July 11th. Linda Hartwell was removed from the HOA presidency by a vote of 39-3. The new president, Robert Martinez, a tax attorney who actually understood property law, made his first order of business a comprehensive review of all Linda's directives. 27 letters demanding compliance with invented violations were officially rescinded. The HOA issued written apologies to 6 homeowners Linda had threatened with fines. Marcus received his personally, delivered by Robert with a bottle of decent bourbon and a sincere expression of regret. She was out of control. We should have stopped her sooner. But the story didn't end with Linda's removal. In August, Marcus learned through the community grapevine that Linda had resigned from the HOA entirely and listed her house for sale. The humiliation of the court case, combined with her removal from power and the neighborhood's collective rejection, had proven too much. She moved to a condo development in the next county by September. Marcus felt no triumph at the news, only relief that the harassment was finally over. 2 months after the court ruling, on a perfect Saturday morning in late August, Marcus stood beside his spillway with his 10-year-old daughter, Emma. They'd spent the morning clearing leaves and checking the stone channels for any winter damage. A ritual Marcus had learned from his grandfather and was now teaching her. The water flowed smoothly over the worn stones, following the path it had traveled for over 6 decades. Emma placed her hand on the spillway's edge, tracing the carved initials Marcus's grandfather had left in 1962 JW for James Webb. Why did that lady think this was hers? Emma asked. Marcus considered the question carefully. Because she thought having power meant she could take what she wanted. She never learned that real authority comes from respecting other people's rights, not ignoring them. Emma nodded thoughtfully. You're smarter than her, Dad. Marcus laughed. I just knew what was mine and wasn't afraid to prove it. Marcus had learned something profound through the ordeal. That sometimes justice requires more than being right. It requires having the documentation, the expertise, and the willingness to fight when someone tries to take what's yours. As he watched the water cascade through his grandfather's spillway, on property that would someday belong to Emma, Marcus understood that standing firm hadn't just protected his land. It had protected everyone in the community from a bully who operated without accountability for too long. Justice, whether delivered in a courtroom or at a community meeting, was worth every moment of the fight. Across the country in Portland, Maine, a Karen named Diane Morrison made the mistake of demanding a veteran remove his emotional support dog from a coffee shop. The veteran, 35-year-old former Army medic James Chun, calmly pulled out both his service animal certification and the Americans with Disabilities Act documentation he carried everywhere. Please, keep talking, he said quietly. My lawyer loves recording discrimination cases. Diane's face went pale as she noticed his phone was already recording. But that's a story for another time.